Hello everyone. Today's session is on law of persons. Law of persons, when compared to other fields of law, is quite familiar to us and also pretty much easier. So when considering the law of persons in Sri Lanka, it is influenced by a mixed legal system. That is, law of persons is governed by the general law, the Muslim law, the Thesavalame, and the Kandyan laws. In the Constitution of Sri Lanka, Article 27 states that the state shall recognize and protect the family as the basic unit of the society. So from this, we can see or we can emphasize how much priority or concern Sri Lanka has given to the family unit or the marriage. So the general law in Sri Lanka is influenced by both the Roman Dutch law and the English law. Mostly general law governs the Low Country Sinhalese people and also the Tamils. The Tamils, whether they are governed by the Thesavalame or not, all the Tamils and mostly the Low Country Sinhalese people are governed by the general law. This is because Thesavalame does not apply to areas regarding marriage, custody and maintenance. Muslim law, of course, governs all the Muslims in Sri Lanka and everyone around the world, every Muslim around the world. And Kandyan law, people who are governed by the Kandyan law has the choice whether they should apply the Kandyan law in their marriage or the general law. So first, we'll go through the first topic. It's the marriage registration. Marriage registration in Sri Lanka is not mandatory, but it's wise to register your marriage because if some problem or an issue occurs or arises in the future, maybe regarding property or custody maybe, then the easiest evidence, it's easy to prove your marriage if you have registered the marriage. If you have a marriage certificate, it's very easy to prove. If not, now, since it's not mandatory in Sri Lanka, still there are instances where the marriage will be valid legally, even if it's not registered. But if some problem occurs, it will be very difficult to prove your marriage if you don't have a marriage certificates. There are main two circumstances where the marriage is legally valid even if it is not registered. The first one is customary marriage. Customary marriage is when you marry according to your religious customs or religious observances. Now, this customary marriage depends or differs according to your religion. For example, for Buddhists, the Perera ceremony. For the Christians, the church ceremony. For the Muslims, they have the nikah ceremony. And for the Hindus, the tying of the thali. So these will be the customary marriage rituals for each and every religion. If you have undergone these customary marriages, you don't have to the registration of the marriage is not compulsory, it's not mandatory. So it is important to remember that these customary marriages should take place in front of a crowd or in the presence of many people, so that they will be able to prove if any problem or issue occurs in the future, they will be able to prove the marriage or they will be of evidence in case of an issue. The next instance where the marriage is considered legally valid even if it is not registered is marriage by habit and repute. This comes to surface when if a couple lives together, if a couple is living together without as husband and wife, without registering the marriage, even then the marriage is considered legal. But there are two factors that the couple should ensure. The people around the couple, that is maybe maybe their family, their relatives or the neighbors or the people around them, should see them as husband and wife. They should recognize them as husband and wife. And the second fact is they should live together for a long period of time. These factors should be ensured in order for a marriage to be legally valid, even if it is not registered, if it is a marriage by habit and repute. There's a case under this marriage by habit and repute, that is Tisalhami versus Nuanahami. What happened here was, after this couple or the husband and wife died, there was issue regarding their property, but they weren't married. Their marriage was not registered, but the Supreme Court held that since they cohabited for a long time and the public was aware in a bigger scale, their marriage was legally recognized. They lived for a long time together, and also their marriage, or the fact that they lived as a husband and wife, was people were aware of it on a bigger scale. The next main topic, or a very important topic when it comes to marriage, is capacities for marriage. This area is questioned often in papers, so you should be very, very thorough with this area. So capacities of marriage are the requirements the couple, or the male and the female should have in order for the marriage to be a valid marriage. The first one is, the first factor is the age. Now, general law is governed under the General Marriage Registration Ordinance. It didn't have a specific age of marriage until 1995. In 1995, Section 2 of the Marriage Registration Ordinance was amended, and it was included that both parties should have completed 18 years in order for the marriage to be valid. So for Canadians also it's 18 years, but for Muslims there's an exception. The age of marriage for a male is not defined in the Muslim Marriage and Divorce Act. And also for females, when they attain their puberty, they are considered as considered as their marriageable age. So if the girl has attained puberty but still under the age of 12, the parents or the guardians should get the consent of the Qazi or the Qazi. Qazi is the Muslim judge who administers religious law in Islam. So the male doesn't have a specific age for marriage in Muslim law, and also the female should attain puberty in order to reach the specific age of marriage. The second factor under capacities for marriage is prohibited degrees of relationship. Now, prohibited degrees of relationship is that the couple shouldn't be within these relationships. If they are within these relationships, they cannot get married. The marriage will not be valid. So there are two sections in which we can get our attention to. The first one is the blood relations. Under the section 16 of the General Marriage Ordinance, blood relations, if you are related by blood, if you are closely related by blood, you cannot get married to each other. And the second one is affinity. Affinity is when you are closely related by marriage. Even if you are not closely related by blood, if you are closely related by marriage, then still you cannot get married. The marriage will not be valid. There are certain sections or relationships that's given under the prohibited degrees of relationships under the General Marriage Registration Ordinance and also the Muslim Marriage and Divorce Act. They are, if either party is a direct descendant of each other. That is, if you consider the male, if the female is the daughter, the granddaughter, maybe the aunt, grandmother, if you are direct descendant, then you cannot get married. Then the second one is, if we consider the male, the female shouldn't be the sister by half or full blood. The female shouldn't be the sister by half or full blood. Then the third is, the daughter of his brother or sister, that is, if the female is the daughter of the male's brother or sister, that is the niece, you cannot get married to your niece or the nephew. Then the fourth one is, if it is the widow of the male's son's grandson's father or grandfather's, then even then you cannot get married. If the female is the widow of the male's father, son, grandson or grandfather, even then you cannot get married to the married, because the marriage will be considered invalid. This under section 17 of the marriage registration ordinance, it states that if two people get married under these prohibited degrees of relationship, it will be considered an offense which is punishable with imprisonment. So the third most important factor under capacities of marriage is bigamy. Bigamy comes under the section 18 of the General Marriage Registration Ordinance and also section 6 of the Canadian Marriage and Divorce Act. So bigamy is a second marriage without the legal dissolution of the first. If you are married to a person and without legally dissolving, that is, if without getting a divorce, if you marry another person, that is called bigamy. And this is an offense under the Marriage Registration Ordinance and also the Canadian Marriage and Divorce Act. But there's an exception for Muslims. Muslims can marry 4 times. That is, a male in Muslim can have 4 wives. So there's a very famous case which is often questioned in papers under bigamy, that is Abhay Sundara versus Abhay Sundara. In this case, what happened was, this person was charged for bigamy. His defense was that he was converted into Islam. So he had the chance to marry 4 times, even though he is only married twice. But the fact was, it was held that this person, he converted into Islam with the pure intention of marrying another person. That is, after the first marriage, this husband and wife both converts into Islam just for the purpose of marrying again. So this was considered an offense, because he didn't convert himself for the sake of converting, but just for the sake of getting married. This person converted into Islam, so it's considered an offense. The fourth factor under capacities of marriage is consent. In Sri Lanka, technically, even if you are above 18 years and if you are below the age of 21, you should get your parents' consent or the guardian's consent to get married. You should get technically, but with having no consent or lack of consent doesn't render an invalid marriage if you are above 18 years, even if you are below the age of 21. For Canadian marriage, you don't have to have the consent, and for Muslims, it's a special case. For Muslims, the males doesn't need the consent of the guardian or the parents in order to get married, but for the females, they should get the consent, whatever the age they are in, the consent of maybe the father of male sibling or any other close male relative. So these are the main 4 elements or the factors that which comes under the capacities of marriage or the requirements of marriage: the age, prohibited degrees of relationship, bigamy, and the consent. Even if you don't have any of these, even if you don't have one of these factors, the marriage will be considered null and void. Null and void is the law or the society will consider the marriage didn't exist from the beginning. That so the marriage becomes invalid from the beginning if any of these factors are not present for the marriage. Then we can get to another important topic, that is breach of promise of marriage. So, Section 20 of the General Marriage and Marriage Registration Ordinance states factors regarding the breach of promise of marriage. So, for breach, first there should be a contract or a promise of marriage. This contract should be a written evidence. It shouldn't be legal or formal, but there should be a written promise. Maybe it can be an SMS or a letter, maybe anything, a written evidence. So this promise should be explicit. It can be implied also, but it should be explicit. There's a famous case which is questioned often. It's always questioned in papers, Udalagam versus Bwange. It was held in this case. Now, the writing should express the promise to marry. There are two types of expressions in this case that should be identified very clearly. The express promise to marry and confirmation of a previous oral promise is different. Confirmation of a previous oral promise and the express promise to marry are different. If it's an express promise to marry, then you don't have an issue, you can just sue the person. But if it's just a confirmation of a previous oral promise, then it will not be enough to prove in court. It will be insufficient. Now this if the promise is made by a minor, this promise is considered invalid or void. It is not considered a promise at all. And the postponement of a wedding is not considered a breach of promise of a marriage. And just like in other contracts, offer and acceptance can be seen in a promise of marriage. Now this offer it shouldn't be in formal language or have any formalities or legalities. It should just be a written evidence, as I said before. But the key requirement is that the person who is making the offer should have the intention of doing so. If that person doesn't have the intention, then it is not considered an offer. And the acceptance must be made within a reasonable period of time. Those are the two main factors in when considering the offer and acceptance, just like in other contracts. And this contract, for it to be enforceable, there should be intention for both the parties, the person making the promise and the person making the offer, and the person who is accepting the offer. Both should have the intention. And the promise should not be induced by duress. If it is induced by duress, then the promise will be invalid. And it shouldn't have any fraudulent aspects to it. That is, if the person who accepts the offer or the person who has made the offer has concealed any factors which will prevent the marriage, then this promise will not be enforceable. Then there should not be any illegal considerations. That is, for example, sexual relationships between the parties. So there are four main factors when it comes to the enforceability of the promise to marry. That is, the intention of the both parties, not induced by a duress, the promise not induced by the duress, not having any fraudulent aspects, and having no any illegal considerations. Now the person or the defendant, if after the plaintiff sues the defendant in courts, the defenses that the defendant can take are lack of capacity. If in case the capacities for marriage, as I mentioned before, are not present, then it will be a defense against the plaintiff against the promise to marry. And the plaintiff's refusal to marry the defendant. If the plaintiff refuses to marry the defendant, after making the promise to marry, if the plaintiff refuses to marry the person or the person who is making the offer, she or he cannot later sue him or her in courts. It will be a defense against the plaintiff. and then proving of physical incapacity or diseases. If the defendant has any physical incapacities or diseases that will affect the marriage, then it will be a defense against the plaintiff in courts. Then when considering the damages, that is, since this breach of promise of marriage has a delictual aspect, you cannot imprison the defendant just for the sake of breaching the promise to marry. You can just get compensation, and these damages are claimed as if the plaintiff is injured. So these are known as pecuniary compensation. There are two types of compensation or damages. That is, the first one, the monetary loss. Monetary loss is the financial loss of the person, or loss of the plaintiff. For example, maybe the plaintiff has given up the job, or maybe the expenses for the wedding. These can be taken back as compensation from the defendant. Then we have the prospective loss. Consider, for example, the defendant is in a good financial position because of the breach. Because he didn't go through the marriage, he is in a very good financial position. Then it is known as a prospective loss, that is loss of advantage. So when these damages are claimed, it is important to remember that the financial status of the defendant will be considered when assessing the damages. It will be definitely considered when assessing the damages. When you write the answers in the paper, make sure you write your own opinions, maybe about the cases or maybe about the laws in Sri Lanka. That will be very helpful for you to obtain marks above average. So the next topic, next important topic we are going to discuss is consequences of marriages. That is, what happens to the husband and wife, or rather what rights changes after for the husband and the wife after they marry. So during the Roman Dutch law period, the rights the wife had was very, very low. The amount of rights the wife had was very less, and it was very discriminatory when it came to the amount of rights the wife had when compared to the husband. So the wife didn't have any contractual rights, or she couldn't sue without making husband a party to the action, and all property, wives and husbands, all property became common property. And also, only the husband had the power to administrate and manage anything regarding property. So this was at present this is changed, and in Sri Lanka, the Married Women's Property Ordinance section number 5 and also the Matrimonial Rights and Inheritance Ordinance has taken away all these laws and amended them. So now the wife can enter into contracts independently. She can sue independently. Also, she could claim ownership of her own property. And also the joint property system was abolished. So these are the consequences of marriage at present, which was changed from the Roman Dutch law system. So these are the three topics that we discussed today: breach of promise of marriage, marriage registration, and consequences of marriages. Hope it really helped you all. I'll give you some exam tips that are important for the exam. You should make sure that the answers you write always depends on the lecturer. So be smart when you're studying. Whatever the answer you write and how you study and how you write your answer, it really depends on the lecturer. So don't study all the subjects in a similar way. It depends on the lecturer, so it will be different how you study and what you include in your answer. Maybe some lecturers, they need bulky answers. Maybe some lecturers, they need answers to the point. And what cases you include. Maybe you have to update yourself with the cases and include them in your answers for some subjects. So you need to make sure that you study according to your lecturer And also make sure you write answers to all the questions. Even if you write only half, don't make sure you answer all the questions, and also at least include at least 4 cases per answer. So those are the important factors you should remember when you're answering the questions. That's all for today. See you in the next session.